Hello. My name is Crystal Dahl, and I am the Online Communications Manager here at Meritas. I would like to welcome and thank each of you for joining us on today's webinar. For those of you that are new to Meritas, Meritas is an established global alliance of closely connected yet independent law firms that each offer a full range of high-quality, specialized legal services. We were built upon a rigorous system for monitoring and enhancing the quality of our member firms and have been connecting clients with carefully qualified business legal expertise in over 250 markets around the world since 1990. Meritas Capability webinars are regularly presented by Meritas members. Before we get started, I'd like to quickly go over a few housekeeping items. Meritas offers the ability to listen to our webinars through your computer speakers, but if at any time you have any difficulty hearing the presentation, you may also dial into the associated telephone line. All phone lines will be muted. If you experience any technical difficulties, please press *0 at any time to connect with the support technician. Since you will be muted, if you have a question, please ask via the chat feature found on the left-hand side of your screen. We will be monitoring all questions that come in and plan to answer those questions throughout the presentation. Lastly, in the next few days, I will distribute a copy of the presentation, a recording of the webinar, as well as each of the presenters' contact details. And with that, Michael, would you like to take it from here?
Thank you. This is Michael Gallagher from Looper, Niedenthal & Logan in Columbus, Ohio. The genesis for this webinar came to me at the Meritas annual meeting earlier this year in San Diego. I'm a member of both the healthcare and cannabis industry groups and realized we're facing a very unusual time in American law. A widely used substance, cannabis or marijuana, has been illegal everywhere in the United States for my entire lifetime. But was moving not only into legality but into mainstream acceptance. This creates exciting and difficult adjustments to lawyers in a wide array of practices. My co-moderator, Janet Jackham from Sachs Tierney in Scottsdale, and I are fortunate to have 3 experts with us today whose talents and experience bridge these two fields. As was mentioned, each speaker will have brief question and answer following their talk. To allow the presentations to flow, the moderators will collect any questions asked during the presentations, and then we'll try to get in as many as possible. As to our first speaker, Lana Ross is a New Jersey-based partner at Norris McLaughlin, where she practices in both the areas of healthcare and cannabis law. She has particular expertise in legal issues affecting healthcare professionals, including the overprescribing of drugs and inappropriate conduct of practitioners. She's going to share her thoughts on legal cannabis with us today. Lana?
Thank you, Michael. So as Michael mentioned, I'm going to spend some time today talking about what physicians and other healthcare providers should consider as they're deciding whether or not they want to incorporate medical cannabis into their practice. I'm a healthcare attorney. I do practice in New York and New Jersey, predominantly in New Jersey. And a large portion of my practice is devoted to representing physicians and other healthcare providers in disciplinary licensure matters and investigations undertaken by government agencies. So I wanted to rely on that experience and share with you my thoughts, recommendations, and some hesitations when it comes to deciding whether or not a provider wants to incorporate marijuana into their practice. So let's see if I can next slide. Yep, okay. So at the current moment, as long as I did my double checking correctly, we have 33 states and the Washington D.C. where marijuana has been legalized for medical use. We have 11 states and Washington, D.C. that have legalized it for recreational and adult use, but it still remains an illegal substance on a federal level. So under the DEA, it is still considered a Schedule I drug. And so as I talk a bit about the incorporation of marijuana into the practice, I'm going to be speaking of it as physicians and providers authorizing it or certifying medical marijuana because they cannot prescribe it. Since you need a DEA license, to prescribe drugs, and Schedule 1 is illegal drugs. They simply can't prescribe marijuana at the current moment. So whenever I talk about cannabis with my clients or doctors thinking about cannabis, I can't help but caution them by reminding them of the drastic shift towards physicians with the opiate epidemic and how the physicians became one of the targets to blame for the epidemic. As Michael mentioned, I do a significant amount of work in that space. And so the landscaping and representing physicians having to do with potential misconduct related to the opioids has drastically changed. So about 5 to 6 years ago, if I was representing a doctor who was being accused of misconduct relating to opioids, meaning not self-abuse, but overprescribing. Usually those types of matters would be resolved in a very simple way, usually a private letter agreement, maybe some documentation courses, maybe some course on prescribing narcotics. But generally, we were able to resolve those cases in a relatively favorable manner to the physician. And then overnight, the political, directives coming in New Jersey changed overnight. Every state has licensing agencies and they're structured differently. But in New Jersey, our Board of Medical Examiners falls under the Attorney General's office. And so when our former governor, Chris Christie, took office for the second term, the fighting the opioid epidemic became one of his top priorities. And so overnight, literally, we went from being able to have a relatively good resolution for the clients to the Board of Medical Examiners resolving the matters with 3 to 5 year revocations and penalties in excess of $100,000. So drastic changes. And now we have, in 2018, we have a new governor, and obviously the opioid epidemic hasn't gone away, but the disciplinary actions have definitely slowed down. So why do I bring all of this up? Mainly because I think that, or my personal thought is I'm hesitant with regard to the push that we're now experiencing with the medical marijuana program in the state of New Jersey. And I am hesitant that if political views change, the physicians stand to be potential targets as well. New Jersey actually has had the medical marijuana program since 2010, but very limited amount of traction or expansion has taken place for the 8 years that Chris Christie was in office, and we really didn't get much development until 2018 when our new governor, the current governor, Phil Murphy, took office. And so when he took office in 2018, our program began to expand pretty much almost quarterly. And so in the beginning, he added 5 additional qualifying conditions, and I think a lot of states have added these as well. We now have anxiety, chronic pain, migraines, which would allow an individual to qualify for the program. This makes up, I think when I checked the last time, probably a little bit over 40% of the patient population with those that have those conditions. And then in January of this year, New Jersey added the opioid use disorder as another condition, allowing patients to consider marijuana for treatment for those purposes as well. And so now we have, at least in New Jersey, we have a very strong push coming from political standpoint to utilize medical marijuana to combat the opioid epidemic. And again, I'm not a clinician, so I don't know if there's validity to this or not, But my hesitation comes from the fact that many of my clients have shared with me that whether they're considering entering the space or whether whether they've already done it or not, many lack the medical and clinical knowledge to counsel their patients. And so where does that leave them, and how exposed are they when they're incorporating the marijuana into their practice? Since it's been illegal, there's very limited amount of research that's taken place in the States. Most of the research that providers are relying upon is coming out of the country. And so, again, they're left with little guidance as to, from a medical standpoint, they find themselves in a situation where they just don't have the expertise. So some states don't even require for you to get any sort of education before you are eligible to authorize or certify medical marijuana. For example, New Jersey is one of them. In New Jersey, if you are interested to becoming a physician that wants to incorporate marijuana into their practice, you can still do so by simply just registering with the state. You don't have to take any CMEs or show that you have any knowledge in that field whatsoever. So my biggest hesitation with it is that there's a political push to incorporate it. But at the end of the day, the decision to authorize it is going to be the physician. And so it must be clinically based, and if it's not, they're potentially exposing themselves to licensure actions and possibly malpractice. There's very limited amount of standard of care. There is lack of disciplinary actions that have taken place by the licensing agencies. There are a few, but none of them actually touch upon the standard of care. There actually have not been any malpractice cases that have had a decision that are related to medical cannabis. Again, this is a very developing area of law. So with all of that as the background, if you have clients or you are a provider that's thinking, do I want to enter the space? Do I want to incorporate medical marijuana into my practice? Here I wanted to talk about some things that should be considered. For starters, you definitely want to talk to your malpractice carrier and make sure, or the provider should talk to their malpractice carrier and make sure that they're protected. New Jersey actually this summer changed their medical program whereby anybody who is a carrier that issues to providers in the state of New Jersey must cover cannabis, and they cannot charge higher rates for the premiums. But prior to that, a lot of them did not cover it, or they would charge more. So that's definitely something you want to double check, because you don't want to be practicing in that space and not have the proper malpractice coverage. You also want to check with your hospital where the physicians or the providers hold privileges. Some of them may have very strict policies and procedures because marijuana is still illegal. A lot of them have issued policies and regulations because they are concerned about losing potential federal funding. You want to check with your employer, obviously, make sure where they stand on that. And one of the important parts is you want to implement written policies. My strongest suggestion is pull out the regulations that the state that you're practicing in, and take a look. A lot of them have details, and make sure that whatever those regulations require, it is captured in your policies. So at least to the best of your knowledge, or to the best of the provider's knowledge, they're following the letter of the law, and that should really help them stay out of trouble. The other part is keeping a treatment plan. A treatment plan, and this goes a little bit more with what I want to talk about a little bit later, is documentation. In defending the opioid cases, one of the biggest elements of defense was having good documentation and having a treatment plan and being able to show from a clinical standpoint that the treatment that was being rendered to the patient was appropriate. And when you lack that, when you don't have that in your documentation, if it's not written down, it didn't happen. It's kind of the approach that's taken by the other side. So you definitely want to capture a good treatment plan and whether or not the cannabis is helping, and whether the patient has any reactions to it, and or any side effects or anything like that. Anything to support the medical judgment issues rendered by the provider. Obviously, know your state regulations and stay current with your state regulations. You definitely want to not just write the policies and procedures. You want to make sure that they stay current. And proceed with caution. I think that's really the theme of my presentation. I'm just going to spend a minute because I think I'm running a bit short on time, but I talked a bit about documentation and regulations by various states. States do have regulations. Not all of them are robust regulations, and so the Federation of State Medical Boards, which is they kind of compiled model guidelines to help physicians in this particular space, and they came up with guidelines that they would suggest physicians follow. And so establishing a physician-patient relationship is one of the recommendations. Making sure to perform a patient evaluation before each and every time you authorize medical cannabis. Having an informed decision by the patient, and I would so far to suggest that physicians may want to have an informed consent form for the patients to sign and capture as much as they possibly can and keep them current as the medical clinical research develops and incorporate them as well. Obviously, make sure you have a treatment plan, as I mentioned previously. Identify the qualifying condition that the patient has that would justify the use of medical cannabis, and definitely have an ongoing monitoring. Capture whether the patient is doing better, whether they're doing worse, whether they needed a higher dose, whether they needed to change the method of consumption, whether the ratio of CBD to THC had to be adjusted. Definitely document as much as possible. And the other piece, and this comes again from really helping physicians in the opioid space, is not to be afraid to send patients for consultations or refer them to other specialists, to make sure that, if the patient is suffering from let's say, chronic pain, aside from just having them partake in medical cannabis, you want to have them see maybe an orthopedist or a pain specialist guide, just to support that the treatment that they're getting is inclusive and is appropriate. With that said, I think I'm not sure if I'm out of time or I'm on time, so if we have time, I will take questions.
You're doing very well, Alana. Thank you. You're doing great.
I wanted to say that.
Okay,
so
well, it was great. And I did have a question. Are you aware of any adverse effects, actions taken on traditional hospital privileges? You mentioned hospital privileges due to physicians being involved in the cannabis industry. Any mainstream hospitals taking a dim view of cannabis involvement?
So I don't know of any adverse actions. I do know that hospitals are treating it very cautiously, at least in the New Jersey space. I know that a lot of them are really looking more from policy and procedures internally on how to address patients coming in with medical cannabis, because they can't really, if a patient comes in with medication, they're supposed to take that and they're supposed to store that and they're supposed to administer it to the patient. A hospital is not going to take possession of medical marijuana because it is still considered an illegal substance. So a lot of them are coming out with written policies to how to deal with it. The one thing I will say with regards to privileges is that I have heard that VA hospitals are much more stricter about what their physicians are allowed to do or not allowed to do, because they are so much closer to the federal component than a regular non-for-profit chain. It is. So definitely, so if you're a physician or your client's a physician and they have privileges or they're employed by VA hospitals, from what I know, VA hospitals are taking a much stronger position with regards to what the physicians can and cannot do, and whether they can and cannot consume themselves as well. So those are definitely things that the provider should double check.
Sure. That's very interesting. I've recently been told that that's an increasing problem with nursing homes and extended care facilities of patients coming in with medical marijuana prescriptions. Well, great. Thank you very much. Janet, would you like to introduce our next speaker?
I would. Thank you. Good afternoon. This is Janet Jackham from Sachs Tierney in Scottsdale, Arizona. Our next speaker is Franklin M. Lee. He is a partner with the Baltimore, Maryland firm of Tidings and Rosenberg. He is one of the country's leading authorities on socioeconomic policies promoting small, minority-owned, and woman-owned business in government contracting. And let's see if we can advance the slide. There we go. His practice focuses on administrative and regulatory law, antitrust, franchise and trade regulation law, and business law. He's a seasoned litigator and appellate counsel representing not only small business but also Fortune 500 corporations, and he has a very long history of fostering better, more accessible governmental policies and practices to minority businesses. His topic is Up in Smoke, when medical cannabis meets the great American melting pot. So take it away, Franklin.
Thank you, Janet, so very much. My topic is really focused on the legal trends in this industry and how they're emerging in terms of the intersection, at the intersection of medicine, economics, politics, and public policy. And I'm focusing on the tremendous amount of apprehension that we have in certain communities in this country, particularly in places like Baltimore, where there's been a certain amount of exclusion of minority-owned businesses from emerging industries. The big elephant in the room is everybody knows this emerging industry is a huge revenue generator eventually for states as well as local governments, and it's also got the potential for providing new opportunities for firms that otherwise have been on the outside on looking at the mainstream of economic activity. So I'm going to focus on three regulatory approaches that we've seen in the mid-Atlantic area, D.C., Maryland, and Virginia, in launching this medical cannabis industry here. It's kind of a murky gumbo, and there's some overlap in these three broad categories, but let me lay them out this way. Selective competition model is one where you've got limitations on the number of providers by category, highly selective criteria for subjective ranking of qualified providers in their license applications. Then you've got more of a free market model, which is kind of what the state of Virginia has focused on, which encourages large vertically integrated providers, objective supply-demand licensing standards, and all of these have some ethical considerations built into the regulatory framework in terms of who can own a particular type of license or business, whether it's a grower, dispensary, or whether you're going to be a medical provider. and what kind of limitations you want to put on that for a variety of ethical reasons. And then the third broad category would be the economic inclusion market model, which focuses on, in the case of Maryland, politically influenced geographic distribution of licenses. They've decided to distribute the licenses for dispensaries based on senatorial districts, which bears no rational relationship to where the demand will be for the product, but it does equally spread out the licenses across the state geographically. And also they're focusing on intentional industry diversification with economic inclusion principles. And also they have limitations. Unlike Virginia, there are limitations on ownership in terms of vertical integration between the grower level, the dispensary level, processor levels. And there's also some limitations here as well in terms of physician ownership of certain types of medical cannabis businesses. The thing we have to keep in mind here is that there's been a long history of new industry development in this country where certain ethnic groups, such as African Americans, have been relegated to the sidelines. The tobacco industry, for one, even though at one time in this country African Americans may have been the major labor force for that industry, development of that industry and plantations and whatnot. There's an industry where you had a product that was highly addictive. It actually led to probably millions of deaths, and it was never criminalized. But it was a highly lucrative industry, and we've seen that industry kind of take its own course in our own lifetime. Then you got other industries like lotteries and gaming, which back in the 20s, 30s, and 40s was an underground industry. They considered basically crimes of moral turpitude to engage in that gambling industry, and now the biggest numbers runners in the country are states, and they're making huge profits from it. So from these kind of ironic differences in the histories of these various industry segments, we've seen a fair amount of problems for certain ethnic groups not being included. So what we're focusing on here is, again, the state of Maryland, Washington, D.C., and Virginia. I want to, at this point, thank my associate, Lauren Ellison, for doing a superb job in developing very detailed charts of the key licensing and regulatory frameworks that have been developed in each of these three jurisdictions for growers, processors, dispensaries, and physicians and patients as well. We're not going to have time to go over all of these things, but I'll just let you know there's several slides here to give you very detailed information about it. For growers, for example, let me pull this up here. I can. You'll see that you can only apply in the state of Maryland. You're going to have some limitations about being able to get an interest in more than one grower application, for example. There's other limitations in terms of dispensaries, in terms of geographic location, the limitations on the maximum number of licenses to be issued. Now that's an interesting one, because in Maryland, which is kind of a much smaller state than Virginia, they've got 15 of these licenses being issued, but in Virginia there's only 5. So Virginia is really trying to promote or set a regulatory framework that encourages vertical integration between growers, dispensaries, and processors, and they're really trying to get the bigger firms to come in and dominate their industry. Washington, D.C. only has 2, but Maryland's got 15. So you'll find some interesting limitations and also regulatory frameworks here for each of these categories and jurisdictions.
Franklin, may I interrupt? This is Janet. What's the significance of the red font versus just black font? Is there?
Oh, the red font was just to point out some highlights. I was just trying to make those jump out.
Thank you. Thank you.
If you've got more time, you can go over all of these. But the other thing I wanted to try to get to is a summary of the key restrictions on ownership. And this is where a lot of the hot spots are in terms of controversies. We've had a couple of lawsuits filed in Maryland already around the licensing process itself, which began in 2015, and we're still in the process of trying to get another round of licenses issued for growers, dispensaries, and processors. The limitations on the single firm ownership of multiple licenses, for example, no more than one grower license in Maryland. We've also got other restrictions such as prohibition against physician acceptance of compensation. That's pretty common in most of these jurisdictions, recognizing the potential for ethical conflicts of interest. And that's true in D.C., Maryland, and Virginia. We've also got limits on the maximum number of grower licenses issued in Maryland and D.C., and I talked about that a little earlier. Limits on the maximum number of processor licenses issued. 28 in Maryland. Again, Maryland's trying to be more inclusive, and by issuing more licenses, hopes to have more indigenous small local businesses involved in the industry than perhaps the other states would. We're looking at licensed dispensaries that have to be formally affiliated with a licensed grower. Only Virginia is doing that of these three jurisdictions that I'm speaking of. And there again, from an antitrust standpoint, that means that you're going to have a much higher concentration of a small number of firms basically dominating that industry. You've also got prohibitions in the other states, in D.C. and Maryland, in terms of vertical integration of various types of licenses. So you can see the divergence in terms of the regulatory approaches that have been taken in the Mid-Atlantic area. And finally, but not least, criminal background checks are required on all of these licensing applications. And in fact, that's going to be a very contentious point, because it turns out, as we'll see in a couple of slides later, there's huge disparities in terms of incarceration and arrest of persons for possession and sale of cannabis as a crime of moral turpitude, which precludes you from not only being an owner for one of these licenses, but also from being an employee of any of these firms that get licensed. And yet, ironically, the folks that have the most experience either possessing or distributing or selling the product before it was considered legal are actually people of color that have been incarcerated. Now, I want to talk briefly about some of these public policy considerations that favor economic inclusion market model for medical cannabis. As I stated at the outset, it's a huge potential industry. I took a trip out to Portland a couple of years ago, and I was just shocked at how much building was going on. There were cranes everywhere and traffic jams that I'd never seen before. And the cab driver that was taking me from the airport said ever since they voted on their referendum to legalize cannabis, they were getting 10,000 new residents moving in to the area every month. And so rents were going through the roof, a lot of congestion. So there's a huge potential impact just in terms of the dollars that will be generated by this industry. And again, D.C., Maryland, and Virginia are all precluding participation in the industry by persons that have been convicted for possession or distribution of marijuana. Now, interestingly, in the state of Maryland, they decided to take a proactive approach to try to encourage more supplier diversity in the industry. and to intentionally recruit firms that were owned by minority persons. And in order to do that, they had to have a factual predicate that would support it. Under the 14th Amendment Equal Protection Clause, no government can issue any type of law that has a racial classification in it unless there is a strong basis in evidence to show that that is necessary in order to remedy the ongoing effects of marketplace discrimination in this case. So in 2018, the state of Maryland hired National Economic Research Associates to do some analysis of a statewide disparity study. That analysis showed racial disparities in African American wage and salary earnings, in business ownership earnings, and in business formation within Maryland, and also related to specific commodity codes in the agricultural field that would be associated with all three medical cannabis license types. The dilemma is, of course, this is an industry that's never existed before, so how do you really show that there has been discrimination or ongoing effects of past discrimination in an industry that has not yet existed? Mm-hmm. But what you can show is that a lot of the criteria that are used by the states in selecting the licensees for these various businesses are themselves fraught with disparate impact in terms of past discrimination. For example, to be a grower, you need to have access to farmland, and we know from a recent case that was settled for a class action of black farmers in the Pickford versus USDA case that millions of acres of land that had been owned by black farmers across the country had literally been stolen by having discriminatory practices by USDA in terms of making loans or not making loans to African American farmers where their crops failed, and then they would auction off their land at pennies on the dollar of what it was worth. So that's just one example of how a criteria that's used in ranking the strength of an applicant could be affected by past discrimination. And there's a number of statistics the ACLU has put out as well about the disparities in incarceration and arrests, about marijuana possession and distribution. The Maryland Medical Cannabis Commission's first round for the issuance of grower licenses, processor licenses, and dispensary licenses actually resulted in near total exclusion of African American license applicants from the emerging medical cannabis industry in Maryland. And trying to figure out why that happened, a number of different ideas were put forward. Number one, that there was insufficient outreach to small local minority women-owned firms. It's not like there's a ready-made directory of firms in the cannabis industry in Maryland. And in fact, a number of these firms are forming for the first time. You also have a number of larger firms that have been active in the industry out west that were trying to move into the area and take advantage of the opportunity. But it was felt that they need to make a much stronger effort just doing outreach to physicians and people with biochemical degrees and other folks to try to see if they were willing to get licensed in this industry. So it was a tremendous effort on the second round of the licensing applications here in Maryland to try to encourage more small local firms and minority and women-owned firms to participate, and apparently those efforts were successful. There's also a kind of a built-in bias in terms of the most well-capitalized, larger, more experienced firms by selection panels. So we know that the idea of taking a whole pool of qualified firms and then ranking them in terms of who gets a license first You're restricting competition by limiting the number of licenses you're going to issue in each category of the industry, i.e. growers or dispensaries or processors. That tends to also have a negative impact on the supplier diversity when you do that. So I'd like to try to leave you with a couple of alternative approaches that are being contemplated as ways to promote competition and at the same time maximize inclusion of small, local, and minority business providers. If the government is interested in making sure that some of its indigenous businesses get to play in the mainstream of this emerging industry, they're going to have to be some rules change in terms of how they go about undertaking the licensing process. The first approach that we're talking about is a two-stage regulated license application process. In that first stage, you're going to look at the license eligibility of all applicants based upon the satisfaction of a single objective minimal qualification standard. What does it take in order to, on a minimal basis, be able to satisfy all the requirements of being a licensed grower, processor, or dispensary? Once you have that pool of qualified applicants, you then have a question of how much you want to restrict competition in order to encourage entry of firms into this emerging industry. And so you're balancing antitrust concerns of free open market competition with other concerns about making sure that this is a well-regulated industry and that the needs of the patients, which is at the core of this, is served well with having a high-quality product. So most states have approached this by limiting the number of licenses that are going to be issued, and you can look at maximizing the number of those licenses to be issued in accordance with objective qualifying patient-provider ratios. Why not look at the demand for the product, where it's most likely to be, rather than just spreading out the licenses all across the state by senatorial district, for example. The other thing that you could do is to set aside a certain percentage of those licenses that you're issuing where only small local businesses or small local business enterprises would be able to apply for them. Because small local business enterprises is a race-neutral classification, strict scrutiny wouldn't be involved. You wouldn't have to have a strong, basis and evidence to support that. And you could do a selection by a random lottery. Once you determine which small local firms are minimally qualified to provide this particular service, you just do a random lottery based on the number of openings. And it's more likely, I think, to probably produce supplier diversity than a more highly selective ranking system, which is inherently subjective to begin with. The second broad approach that we're contemplating is to put into place evaluation preferences for small, local, and minority businesses and competitive ranking process. This is in essence what the state of Maryland has decided to do with this last round of licensing that they're in the middle of right now. And in the process, you have to have a strong basis in evidence. You have to satisfy strict scrutiny under the 14th Amendment Equal Protection Clause. You have to have a factual predicate that supports consideration of those racial classifications. Again, you look at the license eligibility of all the applicants, come up with a pool of only those that are qualified. And then when you have your competitive ranking of those qualified firms to determine which will actually get provisional licenses, you then have to consider the use of what's called evaluation preference points, where you have perhaps maybe 10 or 15 out of 100 points that are awarded on the basis of supplier diversity for those qualified firms. And in that way, you're more likely to get a positive outcome in terms of supply diversity at the end, although you're still going to be at those smaller and local minority firms are still going to be at a competitive disadvantage, most likely in terms of access to capital and access to farmland and some of the other criteria that are typically used in ranking the strength of those applications. So I hopefully I'm okay on time, or maybe I ran a little bit over.
Yes. If we can take questions later, that would be appreciated. And thank you very much, Franklin, for a very interesting presentation. Michael, back to you.
All right. Well, our next speaker is Sean Fraser. He's a Tallahassee, Florida-based partner at Parker, Hudson, Rayner & Dobbs. He advises healthcare providers regarding licensing and reimbursement. But very interestingly, he's been on the cutting edge of legal change in the state.
Michael, we may have lost you.
Cannabis. I'm sorry?
Good. I lost you for a second. Go ahead.
Okay, so take it away.
Thanks very much. I know time's limited. Good afternoon, everybody. I'm Sean Fraser from Tallahassee, Florida. I practice in health facility licensure and certificate of need and do a lot of administrative and regulatory litigation. There's been a lot of litigation as we've broached into the medical marijuana regulation here in Florida. And I tried to step back and see if there's any trends that we could identify as health lawyers that kind of translate to the medical marijuana field, which technically is a medical field. I'm going to briefly go through some of the federal restrictions and then tie the current registration issues to how they might relate to COM. First thing I got to do is figure out how to move the slides along. I wonder if anybody can help me move to the next slide. Gotcha. Thank you. I'm going to start with the federal prohibitions. In 1937, the Marijuana Act prohibited the recreational, industrial, or therapeutic use of marijuana. They actually misspelled it back then. The Controlled Substances Act corrected the spelling in 1970, but made a much stricter form of regulation, classifying marijuana and cannabinoids as Schedule I drugs. That had a high degree of criminal prosecution liability, and if we think about the development of cannabis regulation throughout the country, the start was really in California, where folks starting in the late 1990s started to do statewide programs, usually on a small basis, but at great risk of federal prosecution. If you're old as I am, you'll remember folks starting local businesses, creating inventories and hopefully a viable business plan, only to be raided by the feds and then have to start all over again. In 2009, under the Obama administration, a Cole memorandum was issued that tried to confirm that first, marijuana is still a Schedule I illegal drug under federal law, but reprioritized U.S. attorneys' enforcement efforts and suggested that perhaps that's not the best use of their prosecutorial budgets. It provided some comfort to those medical marijuana entrepreneurs to go ahead and have real businesses and try and be sustainable. However, in 2018, Attorney General Jeff Sessions issued a marijuana enforcement memo that strongly retracted the Cole. It basically rescinded the Cole memo, suggested that standard prosecutorial discretion should apply, and that in that Attorney General's view, medical marijuana still remained a very dangerous criminal drug. In 2019, Attorney General William Barr was testified before the U.S. Senate and was asked about his priorities for enforcement as Attorney General, and he really returned to the Cole memo, although he lamented that federal and state laws were not in concert and he hated the distinction between the two. He thought prosecutorial discretion should really be applied to true problem areas, and that he noted most states with a legalized marijuana program were not reporting problems. So that's the backdrop, and then we get now state legislatures trying to jump into this market, sort of following California. As Lana mentioned, there's 33 states that allow medical marijuana, 11 states that allow adult use or recreational marijuana. And in the chart you see here, there's sort of light colors and dark colors. Those light color states allow for low THC, non-euphoric marijuana, sort of a baby step before people get into higher THC, actually euphoric marijuana, and then eventually to adult use. Florida used to be a light green state. It's now a dark green state, and it allows medical marijuana, but we're having our own fits and start. The number of users is growing. I'll move quickly, but in 2014 there were a few per 1,000 population. 16 it grew, and by 2018 it's becoming more and more popular. The number of regulated states indicates that the number of users of medical marijuana is only going to grow. Some estimates believe there are approximately 3 million people, almost 1% of the population, currently registered to use marijuana in some form. So every state is different because we have this federal lack of authority. Every state can go about creating its own medical marijuana or recreational marijuana program any way it wants to. Some states, as Franklin suggested, are encouraging vertical integration to encourage large-scale providers to invest in their states and create new programs. It's so-called seed-to-sale delivery, where everything from the grower to the distributor to the retailer are controlled in one integrated model. Other states, including California, which I'll suggest is a much more mature program, allow horizontal integration where everybody's separately licensed with some caveats. Just moving quickly, I'll go through a comparison of California, a very well-developed marijuana state, as compared to Florida, which is still going through a lot of litigation as it tries to figure out how and who it will allow to sell medical marijuana. In California, a recent act, as I mentioned, this has started in 1986. There's been 3 or 4 bills passed into law, but the most recent one was in 2018, the Medicinal and Adult Use Cannabis Regulation and Safety Act. It really codified a very horizontal method of licensing separately cultivation from manufacturers, from distributors, and retailers, even including a category for micro businesses. The one caveat there is that testing laboratories must remain independent, but otherwise in California, you can be a cultivator or a manufacturer or a distributor or a retailer or all of those things. There is no prohibition on having separate chains in the license, so it's very much widespread. And the number of licenses there really tells the story. Only a year or two ago, California had about 4,000 active licenses. As of 2018, it had 10,940 active licenses from micro businesses to large-scale manufacturing farms. There's a note there that says only a few dozen of those were annual licenses. I think that relates to a new program. That 2018 law took effect in early 2019, allowed temporary licenses, but those are being converted to permanent now. But there are some market restrictions. This goes a little bit towards where CON and testing who should be the best provider comes into place. It's unlawful to monopolize commerce related to cannabis, so if you have concentration of your brand over others, which is hard to do with 10,000 licensees, that could be enforced. But there's also authority for regulators to deny licenses if the concentration is too great of providers in the market. It's sort of like a CON, is there a need question. If a census tract has a level of cannabis availability that's equal to the counties, then presumably there's no need. But then they also allow for exceptions to that if the development of the legal market means the county doesn't have any usage and you need to sort of start the fire somewhere. Just one other interesting note, most states have a Florida or a state preemption that controls the regulation of who may be licensed and where. That's definitely true in Florida, but in California it's the opposite. If local regulations prohibit the particular licensed activity, then the state law will not trump it and they won't give you a license. Cut to Florida, very different model. Florida requires vertical integration, seed to sale for everything from the farm to the retail shop, and that has been a very limited and difficult market to enter. Only 13 medical marijuana treatment centers, those vertically integrated seed to sale shops, are authorized to dispense currently in Florida. There are 8 more licensees in development. Meanwhile, the patient population has grown tremendously in Florida. There was a 2016 constitutional amendment that allowed for medical marijuana, and though it took a while for the patient registry to start, we're now at about 200,000 patients, up from 100,000 only less than a year ago. So it's growing quickly. These licensing laws and the vertical integration model is being challenged as inconsistent with that constitutional amendment here in Florida, and we'll see where it goes. It's the first DCA has found that the law is actually unconstitutional, but that is pending before the Florida Supreme Court, and everybody's waiting to find out if this model will survive or if a more horizontal model might result. Echoing on some of Franklin's content, there was an effort to make sure that African American farmers, growers, or distributors had a role in the limited number of licensees being authorized in Florida. one of those original licenses that should have been issued pursuant to a statutory timeline was to go to a member of the Pigford class that Franklin mentioned, or to the NRA Black Farmers class action. But a circuit court judge here in Tallahassee found that the class that qualified from Florida in that was really limited to one or two providers and declared that provision an unconstitutional special law. The differences between those markets can be valuation, but there's also some legal implications. I'll just quickly note that because there are so few licenses in Florida, the national providers, really Canadian-based and finance companies, are coming in and buying the licensees who are traditionally farmers from Florida. The valuations are way high, $40 to $53 million in a recent sale for just one of those licenses. If you compare that to California, there's actually an MLS-type real estate system for the sale of cannabis businesses, and they range from a few $100,000 to somewhere less than $1 million, and are much more based on the assets and the market share that they currently exist, rather than speculation about the value of that ability to enter a big market like Florida. So what you're seeing is there's a competition for limited licenses, and in Florida there's been a ton of litigation of folks trying to bang in their way into the license. And full disclosure, I'm one of those folks. And fighting a little bit of executive slow walking of constitutional and statutory provisions that will require them to license folks in a fair and open way. That competition just simply hasn't started, and there's litigation in circuit, appellate, and now the Florida Supreme Court. I can last count more than 50 different cases trying different theories. So I wanted to relate this to CON. I know our time is running out. I'll just mention briefly that CON started as a state program, and then the federal act in 1972 required states to implement individual CON programs and gave a sketch of how those programs should be operated. That still allowed for a great deal of state-to-state flexibility, but at least you had a guideline for what was required before new health facilities could be approved because they needed a CON. But by 1983, because of the DRG payment systems and less worries about cost plus being abused with empty hospitals, the federal law was gotten rid of, and only states could allow CON, but at their own discretion. Most states do still have a CON program. 33, that's the medical marijuana. A majority of states have CON programs of some sort. Many states are seeing a federal effort to undermine those programs. In Florida, we just had a large-scale deregulation just last year. But because they have these limited market shares in vertically integrated required states, some of the CON principles, like federal constitutional principles set forth in Ashbacker, require competitive review, comparative review, and really qualitative decisions among who should get this limited pool of licenses. We're still waiting for that process to open up, but it is much like a CON process where need and ability to serve will become criteria. I know we're running out of time. I'll just mention one little other possible route of federal oversight to maybe bring into some semblance of a rationality between the state-to-state programs. The regulation of hemp has recently been made legal. Hemp, along with marijuana, really the same plant, Cannabis sativa L, had been legal and included in a Schedule I drug for years. In 2014, a farm bill allowed for pilot programs to allow for the use of hemp products with less than 0.3% of THC, the euphoric provision, one of the parts of marijuana that causes euphoria. If it was under that level, it could be grown legal in a pilot program. People were nervous because the DEA still said it was a Schedule I drug. But in 2018, there was a more omnibus farm bill that allowed hemp to specifically be legal in state-to-state programs. That framework of legislation called for the USDA to set out regulations that would then be used to regulate state-to-state programs and require some uniformity. Those were just published a few days, 7 days ago, and the comment period for those USDA regulations are out for the next 60 days. But one quick takeaway is that we could see an easy adoption of these kinds of standards that are already regulating the same plant moved into the legalization of marijuana federally if there's ever a political appetite for it. So I'm not making any predictions. There's been no movement on the federal side that I've noticed. But there could be a sort of federal oversight to state programs which could then kind of control how each state does it. I know I went a little fast. I was trying to make up for time. I'm happy to answer any questions you may have.
Oh, that was great, Sean. I want to press you to make a prediction, though, as a Coloradoan by background. Do you really see a long-term viability for federal illegality, some state medical marijuana and other state recreational marijuana laws? I mean, how long can we go on like this?
In 1997, California started this push. It's taken us 23 years to get where we're at. But in Florida, when the constitutional amendment was set forth on medicinal marijuana, it got 71% of the approval. Nationwide, I think you see there's a disparity between the middle of the country and the coastal communities, but the majority of Americans, I think, now accept, and I don't think view negatively, at least medicinal marijuana. Adult, I think, is another question. I think we're headed in a direction, and the ship's not going to turn around.
Great. Well, thank you. That brings us to the end of our time for today. I'm sorry we didn't have more time for questions, but the presentations were so interesting regardless. I want to thank the presenters, Lana, Frank, and Sean, for sharing their thoughts with us. And of course, special thanks to co-moderator Janet Jackham, who helped me put this whole seminar together. And Meritas organization, the Meritas staff, in the end, made it all possible. So thank you all very much.
Thank you, Michael. Thank you, everybody. From the Meritas standpoint, we're very blessed to have you speak to us today. Before we sign off, I just wanted to remind each of you that in the next few days, I will distribute a copy of this presentation, a recording of the webinar, as well as the presenters' contact details. Please do not hesitate to reach out to them directly if you have any further questions, especially since we didn't have time for questions today. And with that, I hope everybody has a great rest of your day. Thank you for joining us. Bye.
Thank you. Thank you.
Thank you.
Thanks. Bye.